A very warm welcome to this Queen's University Belfast Chief Executives Club event, hosted today in association with the Queen's School of Law. I'm Richard English, Pro Vice-Chancellor for Internationalisation and Engagement here at Queen's, and on behalf of the Vice-Chancellor, Professor Ian Greer, it's a great pleasure to welcome you to our event today, Justice in a Pandemic, and to introduce our distinguished guest speaker, the Honourable Mrs. Justice Keegan. Siobhan Keegan was appointed a High Court judge in October 2015, one of the first two women to be appointed to the High Court. Prior to becoming a judge, Justice Keegan graduated in 1993 from Queen's University Belfast with LLB honours. She was called to the Bar of Northern Ireland in 1994 and became a Queen's Counsel in 2006. During her distinguished career at the Bar, Justice Keegan has served as Vice Chair of the Bar of Northern Ireland, Chair of the Young Bar, Chair of the Family Bar Association, and Chair of the Bar Charity Committee. Justice Keegan was appointed as Judge in Residence at Queen's University Belfast in November 2015, and I'm delighted to say that she continues in that post. In April 2016, she was also appointed as a member of the Judicial Studies Board and remains a member of that board. And since 2017, the Honourable Mrs. Justice Keegan has been the presiding coroner in Northern Ireland. After her address today, Justice Keegan has kindly agreed to take questions. These will be chaired by the head of the Queen's University Belfast School of Law, Dr Marek Martyniszyn. Please do submit your questions using the Q&A function on the screen in front of you, and we'll look forward to seeing those. But now, to speak on the subject, Justice in a Pandemic, it's a real pleasure to hand over to the Honourable Mrs. Justice Keegan.
Well, thank you very much, Professor English, and thank you very much to Queen's University for inviting me. It's an absolute honour to address you today, particularly as I continue to be Judge in Residence, which is, I think, one of my favourite roles. I know there are a lot of you out there, and some of you I know me and are members of the legal profession, so hopefully you'll have some questions and interaction as we go on. For those who don't know me, welcome. I'm very happy to take some questions from different perspectives, and I know some of you are involved in business and other areas. I'm quite energised by a multidisciplinary talk. The title of this talk is Justice in a Pandemic, which is quite a grand title, but nonetheless apt, given two factors that have shaped our lives recently. Obviously, COVID-19 was unpredictable and unprecedented for our generation. And secondly, justice is an ongoing and everlasting concept that we apply in the courts, but also that you as individuals are aware of, alive to, and I think need. So what I wanted to start with was just a step back about the pandemic and what it means. I'm sure, like me, you have all tried to look for pursuits and space to think during a difficult time. But during the height of the pandemic, the poet laureate Simon Armitage wrote a poem to capture the moment, and he aptly entitled it Lockdown. And it's of some reassurance to me, firstly, because it made me realise that this has happened before. He takes us back, in fact, to the plague and 1666. And a small village called Iam in Derbyshire. And a bale of cloth, which contained some fleas, brought the plague to this small village. And it became effectively a lockdown village. It's quite a dramatic story, which, if you follow your history, is replicated in lots of discourse. And in fact, it's quite famous for this. But the village was literally locked down because of the plague, and people were frightened and anxious about what was going to happen to them. And a boundary stone, interestingly, was put in place, which is still there today. You can visit. And it was a stone where people went to buy provisions. So you couldn't leave, but provisions came in, and you put your money in the slats. Now, the stone was sanitized. There wasn't Carex or any of those other things that we had trouble getting for a while, but it was sanitized with vinegar. And the poem's interesting because it also talks about the difficulties that the pandemic or the plague then brought in terms of communication. It tells a rather interesting story about a girl from Iam and a boy from outside who had a difficulty keeping up their romance due to separation and due to what I think probably we now call pandemic fatigue. So the message in the poem is obviously about the difficulties that people face with this type of event, but it is also a poem of hope and recovery. And he describes the process as a journey. And the part of the poem that I particularly like is the ending of it, because he describes the journey as a ponderous one at times, long and slow, but necessarily so. And that, in fact, captures what I want to say about justice in this time of pandemic. So I want to talk about the challenges for leadership during the pandemic, especially drawing from my experience within the justice system. And I'm going to tell you a little bit about how we reacted to these difficult times, then what we've learned, and then I'm going to talk briefly about where we're going. And I'm going to mention the world stage, because I think in this area, it's easy to get caught up with our own domestic issues, but there is actually a much wider world stage. And I suppose that was brought to my attention when I joined a link like this with Hague Convention judges from around the world who were discussing justice in the time of pandemic. And whilst some of us were able to say we had undertaken certain mechanisms to get work back on track, I was very struck, for instance, by a Brazilian judge who just talked about the absolutely devastating circumstances within a poor society. So I'm going to touch on the worldview at the end of this. So starting with how we reacted within the justice system in Northern Ireland, obviously in March 2020, when the pandemic hit, the government reacted by the enaction of some law. And I'm not going to go into the intricacies of that, but it emanated from the Public Health Act, actually, which goes back to 1984, and brought about a change in terms of restricting lives encapsulated in the coronavirus legislation and regulations. Very unprecedented for a society which has, I think, evolved into a place where freedoms are very much protected and advocated for. So as judges and as part of the justice system, we had to think about, well, what does this mean for justice? There are different aspects to justice, but the point that I make is there's a fundamental, which is access to justice. So how do people actually get to court to deal with their problems? And obviously, we had to take cognizance of public health regulations ourselves, because the justice system is multifaceted. We have obviously professional lawyers, and many of the professional lawyers working within the justice system were themselves furloughed in solicitors' offices, or as barristers, as self-employed barristers, were working from home, for instance, or were perhaps even in vulnerable categories. So the justice system obviously doesn't operate in a vacuum. It's powered by professionals who bring the cases to court. There are obviously also staff who work within the justice system, the court service staff who man the courts, and we had to think about them. We also obviously had to think about the people who are affected by law, and this is an area that I think is highly important. You know, law operates in society. It affects all of you, affects me too. And we had to think about how people who are going to be anxious and in need of help can actually access justice during this time. And then, of course, we also had the issue of external providers in certain areas, like probation service, for instance, experts who help us in cases, social workers who are effectively frontline workers. How are we going to deal with that? There were two areas that this particularly, I think, affected. That's not to say all areas of law aren't equally important, but criminal law was obviously affected quite badly because our cases involved jury trials, and there was a problem bringing a large amount of people, 12 people on a jury and other people, to court to hear those cases. So we had to think about that, and I'll talk about that in a minute. But family law was the other area, as you can imagine, which I think struck us as a priority in terms of the courts needing to help to make decisions. And in April 2020, I was appointed as the senior family judge in Northern Ireland, which was quite a time to take over. And I had to think about, well, how are we going to deal with this? Because as you can imagine, people out there were wondering, how are we going to have children having contact with separated parents? It's something as basic as that. I don't know about any of you, but I found the regulations hard to navigate. So I thought to myself, well, it's going to be really hard for some vulnerable people in the community to do this, but the emphasis must be upon maintaining family relationships. And actually, the government themselves at the outset, I don't think properly articulated the emphasis upon maintaining relationships, and had to backtrack to say, look, you can continue to allow children to travel between separated parents. So separated parents was a big issue for me, and I wanted to keep work going to help families in the community, but fundamentally as well to help children. The other area was public care, because there are a lot of children who unfortunately fall into the public care system in Northern Ireland, and they needed assistance during this time to make sure, number one, that cases didn't fall through the net and that the children in care were properly protected. So those were the substantive issues. How you actually deal with that when you can't have people physically coming to court because of public health regulations was a challenge. The legal system, like everywhere else, has thought about innovation and modernization, but these things don't just happen in a minute. But in fact, over the past year, we have adapted and I think embraced a system of remote working that we would never have contemplated. So we took it up. We took up remote working, and I'm quite proud to say that I think the family division led the way in relation to this, really because of the public need to deal with these cases. Remote working is not ideal, obviously, but it at least allowed courts to make some very important decisions and help people with family issues. So that's what we did. We utilised remote working along with some hybrid methods whereby maybe one person came to court. And we prioritised certain types of cases like domestic violence cases where there's an obvious need for an immediate decision, care cases where children were being removed from care. Those types of cases were heard and we got through the work. We also, I think, thought outside the box, both for family law and particularly for criminal law, about alternative venues. And through the Lord Chief Justice's office, there was consultation about this. And we still utilise now the Waterfront Hall for large cases. And we have managed to get jury trials back on track. And we managed to provide a service, albeit a different type of service, but a service. So that's how we reacted. I think I would also pay tribute to the people who are part of the justice system, that many people understood that they had to actually make some decisions themselves. And I think that is a really good template going forward. So we narrowed issues, we narrowed court time, we used the time that we had efficiently, and we tried to be productive within reason. Now, that's what we did. What have we learned? Well, as with everything, there are pitfalls and there are positives. I'll talk about some of the pitfalls. You're all probably aware of all of these pitfalls, I think, in your own working lives. Technology. I spent many days from March 2020, it's not so bad now, saying you're muted, you're frozen, who's in the room, all of that. It's fine, but it is actually quite an extra layer of work for me as a judge, and I'm sure for you as professionals to get that right. And you don't want a situation where there's a fail, but you know, that's just the world, there can be. So technology failings, obviously a pitfall. I think in terms of justice, there is a bit of a problem with the lack of physical interaction between people and the court. And I mean, I think that's obvious in terms of our adversarial system. The need for people to feel that they've had their say fully, to understand court, which isn't easy at times, to have the support of lawyers with you, or to be able to listen directly to the judge. And why there is a problem in certain areas like family law is that a lot of people coming to court are actually vulnerable. They may have learning difficulties. They may have other issues. They may be involved in a difficult relationship. There's an emotional overlay. That's hard to do effectively remotely. So we realized, I think fairly early on, that some cases were just not suitable. And I particularly worried about people at home hearing what may be perceived as difficult news without support, and I wouldn't allow that to happen. There is an issue, and I don't mean to be rarefied about this, about the solemnity of the court as well. The court is a very important place. It is a solemn place. There are very major decisions made, and I don't think it is a template going forward that it's simply beamed into people's living rooms, unless it really has to be. So that's a pitfall, but I think that's something that we can correct going forward. Other issues, delay obviously is problematic for people. It's problematic for law generally in terms of efficiency of the system, but in terms of mental health, I think it's really problematic. And I empathise with people out there who have legal problems, who really want them sorted out, and who don't want to go to bed night after night thinking, oh, that's still hanging over me. So I think that's a pitfall. We also, within the justice system, have people who are represented, I've talked about, but we also have litigants in person. There are different categories of litigants in person. Some want to represent themselves, some can't afford representation. And I think remote working has been challenging for litigants in person. There are some studies that were undertaken by the University of Ulster in relation to this that I've looked at, and I work with a litigants in person group. And I think we have to remember whenever we're looking at different techniques that it may not be a one size fits all. Remote working might be fine for a professional. In fact, it might suit some professionals not to have to travel. But for a litigant in person, I think it can be potentially quite a alienating environment. So I put that as a pitfall. I also put a general pitfall in on remote working, which is the effects on people not being in the work environment. And I hope some of you out there might have your own perspective on this. You know, to have a separation between work and home, I do think is very important. And I do venture that home working has had a detrimental effect on the people having to manage home life, family life, homeschooling, God forbid, and everything together. And perhaps women have been more adversely affected. I mean, no disrespect to the men out there who I know are very much hands-on, but managing a home, managing children, homeschooling is not an easy job. And for professional women, I think we just need to take a step back and think about the effects of this. So it's very easy to knock this system. we took it up as on a contingency basis, and there are issues, and it's not going to be a long-term thing, hopefully. But it is important to mention these pitfalls. But I do also mention some positives. And I think, the positive is convenience in relation to remote working. For some matters, I think it's been really good. I also think it's allowed us to outreach much more. I don't know about you, but apart from spending my life looking at myself on a screen every day at these events, I have been able to interact with judges across the world, I think on a more regular basis, actually, particularly Australia, New Zealand, and I've been able to link into discussions and conferences that I don't think I ever would have before. So that's a benefit. I think also it's made us realise that we can modernise, and it's not going to take forever, but we can do it in a way that maintains some of our original structures. So I'm in favour of a hybrid model. There isn't much that beats human interaction. It's part of law like everything else, but we can combine it with some technological, innovative methods. So I wanted just to mention another thing about how we reacted in terms of where we're going. The background to this is, I'll just mention briefly, COVID litigation, because people have asked me, well, have there been cases about COVID? Is it likely to lead to more litigation? And it's a very interesting area, because if you think about it, the pandemic engages the European Convention on Human Rights in different ways. The government has regulated us and understandably relies on what's called Article 2, which is the right to life. It wants to protect us. But we also have rights and freedoms which are encapsulated in what's called Article 8. There has been some litigation in this area, and the litigation, it seems to me, walks along a line of what's for government, what's for courts or judges. It's an ongoing debate, but I'll tell you about two cases in Northern Ireland, and then I'll tell you about two cases further afield. In Northern Ireland, there was a case taken during COVID by a group of hairdressers who argued that they should get back to work and that the regulations were too restrictive vis-a-vis them. And they, I think, were really saying, look, if you risk assess us, why shouldn't we get back to work? But that case didn't go anywhere because the judge in that case felt that this was a matter for government. We are all individuals, but yet we're part of a society, and the interference was proportionate because of the legitimate aim to protect everybody. That was in the early days, and I think there was a fairly nuanced view taken of that case. The other case I dealt with was a case where a mother came to court whose child was in care and argued that the social services had breached her human rights because she wasn't allowed to breastfeed the child. Now, the child was separated from her, but yet under law, obviously that's a massive interference. And if she's breastfeeding, why should she not be able to do it? So understandably, the authorities, social services, said, well, it's too risky. And I had a lot of sympathy for that view. They're professionals as well, but yet I understood the mother's perspective and the child's perspective. So I suppose what I did, rather than produce some sort of hard-edged ruling critiquing the Assembly, which were absolutely in the thick of it, and I think doing their best to help us, I actually got the parties to write to the Chief Medical Officer because I thought that's the expertise that would assist me. And it was brilliant. He replied within a day and he said, I think this is manageable. It can be done in a certain way. As a result, the Health Board and the Social Services changed their guidance, and this category of person was allowed, with various protections, to have a family life in that way. So I think that was a case that I'm proud of in terms of being able to move forward in a balanced way. The cases at the start of the pandemic, like the hairdresser case, didn't really go anywhere. There's been a bit of a development. There's a case ongoing in the courts about children having sport outside, but it's a bit academic because that's happening. In England and Wales, there was a case taken by Simon Dolan, who's a businessman, who really said, you know, the government is over-regulating here and affecting business. But that failed twice. That failed in the High Court and the Court of Appeal. Again, it failed because of the margin of what's called the margin of appreciation, or the discretion allowed to government to regulate society for society's good, to prevent death and to keep people safe. There's a very interesting case, which finally I'll mention in this part, which is from Scotland, which has just recently been reported on the 24th of March. And it was a case in which a clergyman took a case supported by 26 other ministers, and then a Roman Catholic priest joined as an intervener. And it was about an article of the Convention, Article 9, which is the freedom to maintain religious expression. And the minister said the regulations don't allow worship in our churches. And worship is so important for people, particularly in lockdown when they need some spiritual light and guidance. We think the regulations are too onerous. They also raised a constitutional point, which I won't go into now, but it's a very interesting decision of the Scottish court. It's quite a lengthy decision. And the bottom line is that the court actually found that the government in Scotland was entitled to restrict some mass gatherings, as it were, due to public health. But there were other elements of religious expression, such as private prayer, communion, confession, different types of worship that were important to people. And the court in that case did find that the regulations were disproportionate. So I think there's a progression in terms of the jurisprudence, and perhaps more of a willingness to look at the proportionality of measures in this area. So that's really what I'd say about what we did and the effects. Where are we going? Well, the bigger picture is, I think, one of hope and optimism. We are working towards the courts opening up, its recovery. We have to obviously be cautious, and we are cautious. I think we have to contingency plan, and I'm sure that will apply to all of you, and we are doing it. I think we have to think about the effects on adults and children, frankly, of the past year and a half, and I think they will play out in legal cases. I think the economic effects will play out in many cases in the commercial division, in the chancery division, and there will be an effect on the legal profession, as with all other professions. So, you know, I'm alive to that, and I think we all need to be clear that this has not gone away, but we are now in recovery, and the legal world is in recovery. Final words. I often think it's very easy to be myopic in this area about justice, but there is a bigger world, and I was reading with some interest some discussion about the justice gap throughout the world. You know, we have access to justice here. I know we continually look at it, and there are critiques about it, but we do have it. I was struck by the fact that there is a discourse at the minute about the effects of the pandemic on the justice gap throughout the world. By justice gap, I mean people who live in poverty, people who are victims of human trafficking, people who are discriminated against, people in the developing world who really don't have the same access to justice that we have in our society. And in 2015, the UN member states adopted 17 Sustainable Development Goals, which they hope to progress by 2030. And it's interesting that Goal 16 involves access to justice. And I worry about this because the statistics from the World Justice Project, which is debating this at the minute, talks about people in their billions, 5.1 billion people, having globally unmet justice needs, such as the basics: not having a legal identity, not having proof of their land rights, or their housing rights, being victims of slavery, and being residents in conflict-ridden states. There are also the statistics that I read recently, 2.1 billion in the informal economy. And again, that's something that I'm sure will resonate with many of you. Due to unemployment, due to businesses failing, the informal economy does not provide the protections for people that they should have. So there is going to be a wider picture. And I don't think we can just simply sit back and say, well, it's not part of our society, because our society does now have lots of people in it who come from other jurisdictions and who are affected by these types of issues. So I'll finish by saying this. I'll go back to Simon Armitage and the poem I mentioned at the start. It has been quite a ponderous road, but I think we've adapted, and I do maintain a hope and a vision that we have come out wiser from this experience. I think we have had more understanding of our own fragility, the need to work together, and the importance of access to justice. So I think I'm on time. Thank you for listening. And I really do hope there's some questions out there which I'll try my best to answer. Thank you.
Thank you so much, Justice Keegan. Justice Keegan has very kindly agreed to take some questions. And please feel free to post them using the chat function. We have already received some questions in advance, and I'll start with them, if you don't mind, Justice Keegan. The first question to you. Lord Wolfson, the Justice Minister in Westminster, has been quoted in the recent edition of The Economist, saying that online justice is not secondary justice, it's justice. Moving beyond the pandemic and thinking about the future, to what extent online justice carry the potential of helping us as a society to deliver justice more timely and more efficiently? What particular tools and instruments should stay with us?
Yeah, well, there's an ongoing debate about online justice, and I think it's quite a wide topic. For instance, there are different aspects to this. Remote working will be part of justice in some form. I think it'll be hybrid. In other words, some people will be remote, some people will be in person. I think that's efficient and cost saving potentially, so that's a good thing. The bigger picture, which I'm not sure really there have been enough studies to work out whether it's effective, is, for instance, online dispute resolution. Now, some countries like the Netherlands trialed this, but it didn't really work. The model is from eBay, and online dispute resolution works very well. But the complications of law are many and various. For instance, you may have litigants who are not so technologically savvy as others, or who have vulnerabilities and difficulties. There is a pilot in Northern Ireland that is going to be taken up about potentially online dispute resolution in small type claims. And I think we'll just have to wait and see. What we don't want, though, in any society, I think, is a two-tier justice system. In other words, that some people can have a court hearing in a particular way and others have to revert to something. It's not a one-size-fits-all. I'm open to the debate, but I just don't think there's enough research on this at the moment. We live in a small jurisdiction, and anything we do must, I think, suit all of the people within our jurisdiction and not just, be for the sake of it. I'm all for saving money, but I think it needs to be thought through, put it that way.
Thank you so much. Another question concerning administration of justice. Can a hearing be considered held in public when the number of persons attending is limited or restricted, and in the absence of live streaming of the said hearing?
Yeah, that's a great question, and I meant to mention open justice. Open justice is extremely important, and it has been hindered a bit by online means. However, we have adapted a system whereby the press have linked in to hearings. That's extremely important. So we have allowed that to happen, and in fact, in some cases, there have been applications for lots of people to link in. Can the public link in? I think that's just a bit more difficult, but it has happened. So I think we're in as I've said, an unprecedented situation. We do maintain and keep an eye on open justice. It's not ideal, but certainly I don't think we have refused media access or people, if they have a valid interest, coming to court. It's just more difficult to monitor, because you can imagine, certainly in sensitive cases, there are rules about privacy and dissemination of information. So there's quite a lot of work needs done, but it's a great question. Open justice should remain and will remain, but we have to do a bit more work whenever we're dealing with it remotely.
Thank you so much. Another related question, a more factual one from the chat. Is there a big backlog of cases now? And if so, how it will be addressed?
Yeah. There is a backlog of cases in some areas. As you can imagine, jury trials are one, but the judges who deal with the jury trials are currently working to improve court space and get through those cases. And I think from certainly September, that will be fast-tracked. In other areas, there's not so much of a backlog, certainly not in family, which I manage. Other areas, I think, are gradually coming back. We will use our judicial resources as best we can to deal with this backlog, but we also rely on the profession to assist us. I think in law, it's quite important to isolate the cases that are potentially solvable as well, and use mediation or use techniques to solve cases, and then prioritize the cases that really need adjudication. But we're committed to that structure, and the Chief Justice is committed to it through active case management, and that's what judges do. So we pick out the cases that are ready to go, and we're certainly ready to go if people can come to us with their problems.
Thank you so much. How far have the somewhat chaotic processes associated with the pandemic exposed a pre-existing problem with how law and guidance are made, publicized, understood, and enforced?
Sorry, could you just repeat that? I didn't catch the start of that.
How far have the somewhat chaotic processes associated with the pandemic exposed a pre-existing problem with how law and guidance are made, publicized, understood, and enforced?
Okay, well, I think if the question is the issue of guidance within the court structure, I think we have, in a sense, been quite well advanced on that. We, through the Office of the Lord Chief Justice, have issued guidance on a regular basis to tell people how to deal with their cases. For instance, to tell people that they can complete a form, and a judge will look at the form in writing if there's something urgent, and then decide what to do. And we've adapted as we've gone along. I wouldn't suggest that it's, I think the word was used, chaotic. I don't think it was chaotic. I think it was a challenge. But we adapted to it like everything else and got through it.
Thank you so much. And I have one more question about administration of justice from the perspective of the law school. With your experience of justice in a pandemic, does facilitating online justice require specific or simply different skills and attitudes? If yes, what types of skills and attitudes should legal educators be focusing on more intensively going forward?
Yeah. That's, again, quite a convoluted question. It's hard to say. I think through the past year and a half, certainly judges have realised that online working is different. We have used paperwork in addition to oral hearings. In other words, we've asked people to present a written argument to make sure that we haven't missed something. I think there's a lot more patience involved. I think there's a lot more case management involved. And to go back to the last question, which I've now read a bit better, we have publicised on the judiciary website all of our guidance. And that's part of this outreach to the community, so that people understand what they can do, what we can do, and what the expectations are. But in terms of the issue going forward, I think it's going to be part of training. For my own part, I think remote working is a lot more tiring than face-to-face interaction. I think we have to keep an eye on that and probably train professionals in techniques and effective advocacy over the internet or the video link is different from face-to-face advocacy. But we do rely in our system on written advocacy as well quite a lot. So again, that's something that I think we can pick up in training.
Thank you so much. I'll turn now to a set of questions we received in relation to your own career. Did you ever have a mentor, and what are your views on mentoring within the legal profession?
Yeah, I have not had a mentor myself, but I have been a mentor for a number of people when I was at the bar, and since I've been a judge with other new judges. I think it's really important. I don't think you can underestimate the utility of a mentor in an area where you're perhaps different, where perhaps there's underrepresentation of a certain group. The mentoring that I did was part of a Women in Law program for women professionals in law, and it was to really assist and give some ideas from my career path as to how people could progress to senior positions. And I think it's really important. But interestingly, I do keep up to date on this. I do think it's also important to think about reverse mentoring, funny enough. I read about city firms that do this. I don't know if any of you do it, but city firms, I think quite bravely, allowed a mentoring system whereby their senior execs were mentored by the most junior people. And what the junior people were saying was, hold on, do you realize, and the people did, and the senior execs didn't realize, do you realize that by the way you conducted that meeting, you totally, ruled me out. I didn't have my say. I felt sidelined, XYZ. So I'm actually a fan of mentoring two ways. And I don't think it's just a mentoring of women. I think it's a mentoring across the board. And I think it's a very important aspect of the legal world, and I'm sure the business world. And it's a very important aspect of well-being as well, to have a mentor. So I suppose in a way I wish I had a mentor, and I may try and get one. But I have certainly got a lot out of being a mentor from the people I have mentored.
And I have a related question then. What is the most valuable piece of career advice you were ever given, and how did it affect your career path?
Well, I think the best piece of advice is just to work hard and believe in your own abilities. It's very easy to get downhearted by the knocks that you get along the way, and we all do. The disappointments, the cases that don't go well for you, the business deals that don't go well for you. But you pick yourself up and you believe in yourself, and you move on to your next project or your next case, and you believe in your own ability. And ultimately, I do think that personal belief is the best driver for progress.
Thank you so much. And is there a good system of professional support available to those who may be interested in becoming a judge, and for those at your current level?
Yeah, I think we're doing better at this, certainly through the professions, because it's got to start with the professions from which judges are largely drawn. So I know in the Law Society have a really dynamic program of law care or law well-being. They actually publicised there recently a well-being week, and this was always seen as a bit of a difficult area to perhaps articulate, because I'm sure it's the same with lots of professions. Having difficulties or articulating stresses was maybe seen as a sign of weakness. It's actually not. It's a sign of strength. And the Law Society have picked this up really well, as have the Bar Library. And it is also now part of judicial training to have an eye on well-being. There's some very interesting debate about this in this jurisdiction, but in England and Wales, the president of the family division, Sir Andrew McFarland, gave a paper recently about the need for lawyers to turn off the computer. You know, with remote working, I don't know about you, but there is an accessibility issue. You could be on the computer all day, all night. The need to manage your time and think about your own health, because at the end of the day, if you overload, I don't think you can think things through properly if you don't have space and if you don't have other pursuits in life. Now, I do have other pursuits in my life that I value because that gives me time away. And those are the sort of things that the profession have picked up and the judiciary pick up too. That, you know, you've got to have a healthy work-life balance, and I think fundamentally be a contented person to be most effective at work. So thank you for the question. It's an area that I'm really interested in and that I promote, and I'm really glad that the professions have embedded it in their structures and that judiciary have it now as part of training.
Justice Keegan, we have one last question related to career. Do you belong to any professional networks? And if so, why?
Okay, the answer is no. So that's a very quick question to say no. No, I don't. I suppose my networks would be informal. I do find it important to interact with other judiciary, both in Northern Ireland, in the UK, worldwide, and the professions, but I'm not formally part of other networks. I know that's slightly different, perhaps, to the business community, but my networks are more informal and drawing on people who are in similar positions to me and talking to them and exchanging ideas.
Allow me to ask the very last question. What aspect of your current role do you find most stimulating and enjoyable, and why?
Yeah, well, I mean, I'm in a very privileged position judging and dealing with issues that are really important to people. So making decisions that clearly matter and have an impact is both a huge responsibility, but is also hugely satisfying. And I think for me personally, through my career trajectory, doing different types of work has been really energizing intellectually, and also has, I think, kept me really motivated and sharp about law and how law affects society in so many different ways and in so many different areas.
Thank you so much for engaging so well with a variety of questions asked by our attendees today. And with this, I'll hand back to Professor English. Thank you so much.
Okay.
Marek, thank you very much indeed. And thank you so much for those wonderful comments, both in your talk and also in answering and fielding very honestly and with a theme of hope, I think, a theme of positivity, the questions that were wide-ranging. It's been a fascinating discussion as a non-lawyer to listen to, both in terms of insights around the legal profession, but also around societal challenges, opportunities, learnings, pitfalls, the positive, the negative, and how to move forward, but a sense of real optimism in so much of what you were saying. In closing the event, let me offer three expressions of thanks. First, thanks to the audience. Thank you for your engagement with the Chief Executives Club, and thank you for the wide-ranging questions around law, around society, around justice in a pandemic, and around career advice. All of that was very valuable, and we look forward to having you at future events at Queen's, whether as today they're virtual online events, and or in the future when we have a mixture of people back on campus in person and online events. We really want to continue your involvement and look forward to the privilege of that. Thank you second to my colleagues at Queen's, to the public engagement team, and to Marek and his colleagues in the School of Law for organising this event. One of the things we've tried to do at Queen's during this period is to make sure that there is a sense of ongoing dialogue, of listening to people, as our speaker today, who've got great expertise and insights and wisdom, and making sure there's an opportunity for the debate that we would in normal times continue to facilitate happening despite these unusual circumstances. So thank you to them for organising it so well. But for a wonderful address and for an absolutely wonderful fielding of questions across a wide-ranging set of issues, and for an inspiring optimism despite the context that we face. On behalf of the Vice-Chancellor of Queen's, on behalf of the Chief Executives Club, on behalf of the School of Law, and on behalf of the entire audience, I'd like to say a profound word of thanks to our distinguished speaker today, the Honourable Mrs. Justice Keegan. Thank you very much indeed.
Thank you.